There are active court orders against Nyesom Wike. There are judges who have the authority to commit him to prison. And as of today, Wike is not in prison. That gap between the court orders that exist and the enforcement that has not happened is not a mystery. It is a window into exactly how power operates in Nigeria, who it protects, who it exposes, and under what conditions the law decides to move. Nyesom Wike has been at the center of Nigeria's most consequential political storms for a decade, as governor of Rivers State, as the man who destroyed the PDP's 2023 presidential campaign from within, as the Federal Capital Territory Minister who demolished Abuja communities in operations that courts have found to be unlawful, as the man whose political future is now directly tied to whether Tinubu keeps him or discards him before 2027. But behind all of that political theater is a set of legal proceedings that most Nigerian commentary has treated as background noise. They are not background noise. They are the most direct threat to Wike's freedom that any Nigerian politician has faced while still holding federal office. Today, AFRONEWSHQ is going inside those proceedings, the specific cases, the specific orders, the specific judges, and the specific reasons why those orders have not yet been enforced. Most channels will give you the headline. We give you the architecture behind it. If you've never been here before, you just found Nigeria's most analytical political channel. Subscribe, because what comes next in this video is the part they hope you never piece together. The Abuja demolition cases, what the courts have actually said. The most active legal threat to Wike emerges from his tenure as FCT minister and the demolition operations he ordered across Abuja. Let us state the documented record precisely. Between 2023 and 2025, Wike's FCT administration conducted multiple demolition exercises across residential and commercial areas of Abuja, in Maitama, Gwarinpa, Kuje, and other districts. The government's stated justification was the recovery of illegally allocated land and the enforcement of Abuja's master plan. Property owners went to court. Federal High Courts issued orders in multiple cases restraining further demolitions. Some of those orders were issued before specific demolitions occurred. In documented instances, the demolitions proceeded after the court orders were served. That sequence, court order issued, demolitions proceeds anyway, is not merely a civil liability matter. It is contempt of court. And contempt of court in Nigeria carries a specific remedy: committal to prison. In at least 2 documented cases that AFRONEWSHQ has tracked through court filings, contempt applications were filed against Wike personally and against FCT officials acting under his authority. Those applications named him as the responsible decision-maker. Those applications alleged that demolitions proceeded in defiance of subsisting court orders, and those applications sought committal to prison as the appropriate remedy. The Rivers State cases, the older legal shadow. Beyond the Abuja demolition cases, Wike carries legal exposure from his Rivers State governorship that has not been fully extinguished. Several civil cases relating to contract disputes, property rights, and the conduct of security operations during his tenure remain active or were settled without full legal resolution. The Rivers State cases do not individually carry the same immediate criminal exposure as the contempt proceedings, but they represent a legal landscape around Wike that is denser than any commentary focused purely on his current FCT role acknowledges. The specific legal mechanism of committal for contempt of court in Nigeria, how it works, what a judge must find before issuing a committal order, and why it is harder to execute against a sitting federal minister than the law's text suggests, is the most important thing to understand about why Wike is not yet in prison. We will return to it. There is a documented pattern in Nigerian legal history of contempt proceedings against politically connected individuals moving very slowly or being resolved through behind-the-scenes settlements that are not publicly disclosed. We will examine whether Wike's cases fit that pattern. How committal for contempt works in Nigerian law. To understand why the judges who could send Wike to prison have not yet done so, you need to understand exactly what the law requires before a committal order is issued. Contempt of court in Nigeria is governed primarily by the Sheriffs and Civil Process Act, by the Federal High Court Civil Procedure Rules, and by the inherent jurisdiction of superior courts to protect the integrity of their own orders. The remedy for contempt, committal to prison, is a severe one, and the procedural requirements for obtaining it reflect that severity. First, the applicant must establish that a valid court order existed at the time of the alleged contempt. This requires producing a certified true copy of the order and evidence that it was properly served on the respondent or their authorized agent. Second, the applicant must establish that the respondent had actual knowledge of the order at the time of the alleged contemptuous act. Service of the order is the standard mechanism for establishing knowledge, but disputes about the timing, mode, and completeness of service are the most frequently litigated issues in contempt proceedings. Third, the applicant must establish that the respondent deliberately and willfully disobeyed the order. Accidental or inadvertent breach is a defense. The court must be satisfied beyond reasonable doubt, the criminal standard of proof, that the breach was intentional. Fourth, the respondent must be given an opportunity to purge the contempt before committal is ordered. This means the court typically gives the respondent a period, sometimes days, sometimes weeks, to comply with the original order and to apologize to the court. Only if the contempt is not purged does the committal order become executable. Each of those four requirements creates a procedural battleground that a well-resourced respondent with competent lawyers can contest, extend, and delay. And Wiki is an extremely well-resourced respondent with access to very competent lawyers. The judge's position is more vulnerable than most people understand. A Federal High Court judge who issues a committal order against a sitting federal minister is not simply applying the law. They are initiating a confrontation with executive power that has specific career implications in Nigeria's judicial environment. The National Judicial Council, which oversees the appointment, promotion, and discipline of federal judges, is chaired by the Chief Justice of Nigeria, who is appointed by the President subject to Senate confirmation. That structural dependency of the judiciary on the executive does not make judicial independence impossible, but it creates a context in which a judge issuing a highly politically sensitive committal order must be prepared for the institutional consequences. That calculation is not theoretical. It is the lived reality of Nigerian judicial practice, and it is one reason why the judges who have the legal authority to commit Wike to prison have not yet exercised it. The political strategy layer. Why Wike's legal exposure has not translated into political vulnerability. Wike's political survival in the face of active court proceedings is not accidental. It reflects a deliberate and sophisticated strategy that has three components. Component 1. Federal protection through utility. As long as Wike is politically useful to Tinubu's 2027 re-election architecture, as a Rivers state mobilizer, as a South-South coalition anchor, as a man whose network reaches into PDP structures that the APC needs to fracture, the executive branch has no incentive to encourage the judiciary to move quickly on his contempt proceedings. Federal protection is not always explicit. It is often simply the absence of pressure on institutions that would otherwise move faster. Component 2. Legal attrition. Wike's legal team has pursued a consistent strategy of procedural contestation, disputing service, seeking adjournments, filing counter-applications that require resolution before the contempt hearing can proceed, and appealing interim decisions to higher courts that then issue their own restraining orders. This strategy does not require winning any individual legal argument. It requires keeping the proceedings moving slowly enough that no committal order reaches the execution stage while Wike remains politically protected. Component 3. Settlement pressure. In multiple documented Nigerian contempt cases involving politically connected individuals, the proceedings have been resolved through private financial settlements with the original applicants, settlements that satisfy the underlying property or contract dispute without the court ever issuing a formal contempt finding. That route remains available in Wike's cases as long as the applicants can be persuaded that a financial settlement serves their interests better than a long contempt battle. The Abuja demolitions contempt cases are being managed, not litigated. The pace of the contempt proceedings against Wike in the Federal High Court Abuja is not the pace of a prosecution being vigorously pursued. It is the pace of proceedings being managed by a combination of legal procedural delay, adjournment culture, and the absence of prosecutorial pressure that characterizes Nigerian courts when the respondent is sufficiently connected. The question that AFRONEWSHQ is asking is not whether contempt was committed. The documentary record suggests it was in at least some of the cases. The question is whether Nigeria's judicial system will process that documentary record at the speed the law contemplates or at the speed that political management permits. Those are very different speeds. Now let us look at what this gap between legal exposure and enforcement costs Nigerian democracy and whether the cases are likely to move before 2027. What the Wike cases reveal about Nigerian rule of law. The specific question of why Wike has not been committed to prison despite active contempt proceedings is a narrow legal question, but the answer to that narrow question illuminates something much broader about the Nigerian state. Rule of law in any political system is not simply the existence of laws and courts. It is the consistent application of those laws and courts regardless of who the respondent is. A legal system that moves quickly against ordinary property developers who defy court orders but slowly against federal ministers who do the same is not a rule of law system. It is a rule of law system with a political override function. The political override function in Nigerian judicial practice is not written anywhere. It does not appear in any statute or court rule. It operates through the accumulation of individual judicial decisions about when to grant adjournments, when to expedite hearings, when to apply the full rigor of contempt procedure, and when to allow the softer resolution of purging and apology. Each individual decision is defensible. The pattern of decisions, aggregated across many cases involving politically connected individuals, reveals the override function clearly. The Wike cases are one data point in that pattern, but they are a high-visibility data point, and their resolution or continued non-resolution will be watched by every Nigerian who has ever had their property demolished by a government official, gone to court, obtained an order, and then watched the demolition proceed anyway. The property rights dimension. The Abuja demolition cases are not abstract rule of law questions. They involve specific Nigerian citizens who owned or occupied specific properties, who obtained specific court orders protecting those properties, and who then watched those properties demolished in defiance of those orders. For those citizens, the contempt proceedings are not political analysis. They are the difference between justice and the confirmation that in Nigeria, court orders are documents rather than protections, that a government official with sufficient political cover can demolish your property, defy the court order you obtained, and face no personal consequence. That confirmation, if the Wike cases resolve without a committal order, will shape how Nigerian citizens relate to the court system in property disputes involving government actors for a generation. It will tell them that going to court is an expensive delay mechanism rather than an effective remedy. That institutional message is more damaging to Nigerian democratic development than any single political controversy. The strongest counter-argument. The most serious defense of the current pace of proceedings offered by legal practitioners who are not partisan to Wiki is this: Nigerian contempt proceedings are slow for everyone, not just for politically connected respondents. The adjournment culture, the procedural complexity, and the case backlog in Nigerian federal courts produce slow outcomes across all contempt cases, regardless of who the respondent is. That counter-argument is partially true and worth taking seriously. Nigerian courts do move slowly. Contempt proceedings across the board are not swift, and it would be analytically unfair to characterize the pace of Wiki's cases as uniquely political without acknowledging the systemic slowness of the broader judicial environment. What the counter-argument cannot account for is the specific pattern of adjournments, counter-applications, and service disputes in Wiki's cases that suggest active management rather than passive systemic delay. There is a difference between a case that moves slowly because the court is backlogged and a case that moves slowly because every hearing produces a new procedural obstacle that requires resolution before the substantive issue can be addressed. Wiki's cases show more of the second pattern than the first. The applicants in the contempt cases are under pressure that only Wiki's network can explain. In multiple Nigerian contempt cases involving politically connected respondents, the proceedings have slowed or stalled not because of court adjournments, but because the original applicants have quietly withdrawn, settled, or become suddenly unavailable to pursue their cases. In some documented instances, applicants in politically sensitive cases have been approached with offers of alternative accommodation, financial compensation, or more informal forms of pressure that make continued litigation unattractive. AFRONEWSHQ cannot confirm that this is happening in Wiki's specific contempt cases. What can be confirmed is that the pattern exists in Nigerian history and that Wiki's network has both the motivation and the resources to pursue it. Rule of law assessment. The gap between the active contempt proceedings against Wiki and the absence of a committal order is not a gap that the law created. It is a gap that political management maintains. And the maintenance of that gap is itself a form of institutional corruption that is more damaging than any single act of contempt. Why the committal mechanism is harder than the law suggests. We said we would return to why committing a sitting federal minister to prison for contempt is harder than the law's text suggests. The answer has three layers. First, the procedural requirements for contempt, proving service, proving knowledge, proving willfulness, giving opportunity to purge, create multiple hearing stages at each of which delay is possible and normal. Second, the judicial career environment creates institutional pressure on individual judges that is not explicit but is real. A judge who commits a federal minister to prison initiates a confrontation with executive power whose consequences for their career are unpredictable and potentially severe. That pressure does not make judicial independence impossible, but it raises the cost of exercising it. Third, the Ministry of the FCT and the Office of the Attorney General of the Federation, both under executive branch authority, have access to procedural interventions that can complicate contempt proceedings without directly obstructing them. Instructions to government lawyers on how vigorously to contest service, how broadly to frame jurisdictional objections, and how actively to pursue parallel proceedings that stay the contempt hearing are all within executive discretion and do not require any explicit instruction to obstruct justice. Does this fit the pattern? We asked whether Wiki's cases fit the documented pattern of contempt proceedings against politically connected individuals moving slowly. The answer is yes, with the specific additions of legal attrition and potential applicant pressure that place his cases at the more managed end of the slow proceedings spectrum. The historical precedent that is most relevant is the pattern of contempt proceedings against state governors during the Obasanjo years, cases where court orders were defied, contempt applications were filed, proceedings moved slowly, and resolution came through political transition rather than judicial enforcement. The governors who were eventually held accountable in those proceedings were almost exclusively those who had lost their political protection. The ones who maintained federal executive alignment resolved their cases through settlement or outlasted the proceedings through attrition. Wike's situation maps onto that historical pattern precisely. As long as he maintains his utility to Tinubu's 2027 architecture, the proceedings will move at the pace that political management permits. The moment that utility expires, the moment Tinubu no longer needs what Wike provides, the pace of those proceedings will change. The trigger that changes everything. There is one specific political event that would dramatically accelerate the Wike contempt proceedings, a public falling out between Wike and Tinubu before 2027. Nigerian legal history provides the template. When Obasanjo and Atiku fell out, Atiku's legal exposure became a political coup. When Buhari's relationship with various governors deteriorated, those governors' legal cases were suddenly expedited. The Nigerian judiciary's pace is not simply a function of case complexity, it is a function of political temperature around the respondent. Wike knows this better than almost anyone in Nigerian politics. His entire strategy of maintaining sufficient utility to Tinubu's 2027 architecture is built on the understanding that his legal fate and his political relationship with the presidency are not separate questions. They are the same question, answered by the same person. 3 signals to watch. First, the scheduling of contempt hearing dates in the Federal High Court Abuja. A sudden acceleration of hearing dates, multiple cases listed for hearing within weeks rather than months, is the earliest signal that the political protection calculus around Wike has shifted. Second, Wike's public posture toward Tinubu. As long as Wike maintains his deferential posture to the presidency and operationally aligned with APC's 2027 strategy in Rivers State and the South-South, the political protection holds. A shift in tone, public criticism of Aso Rock, alignment with opposition figures, or open defiance of federal political direction is the signal that the utility calculation has changed. Third, whether any of the applicants in the contempt cases publicly withdraw or suspend their proceedings. A withdrawal from applicant's side signals either a financial settlement or a form of pressure that has made continued litigation unattractive. Either outcome confirms that the cases are being managed rather than litigated. The judges who could send Wike to prison are not cowards. They are not all corrupt. They are operating within an institutional environment in which the gap between legal authority and political consequence is real, documented, and career-defining. The law says Wike can be committed to prison for contempt. The facts, based on the documentary record of the demolition cases, suggest that the grounds for committal exist. What is missing is not the legal mechanism. What is missing is the political condition that would allow the legal mechanism to operate without the political override function intervening. That political condition has a name. It is called a Wike who has lost his protection. And whether that condition arrives before or after 2027 is not a legal question. It is a question that Tinubu answers every morning when he decides whether Wike is still more useful inside the tent than outside it. Watch the hearing dates. Watch Wike's tone. Watch the applicants. Those 3 signals will tell you, before any announcement does, whether the judges who have the authority to act are about to be given the environment in which acting is survivable. You now know something that most Nigerians watching the news tonight do not know. What you do with that is up to you. Share it, debate it, challenge it. That is how democracies survive. AFRONEWSHQ. Nigeria deserves better analysis. See you in the next one.